SJC-12719, in the matter of an impounded case.
Ms. Krasner, good morning.
Good morning. May it please the court, I'm Sherrie Krasner, here today on behalf of Mother. Trial judges make decisions in care and protection cases that can change the course of a child's life. Because these decisions are so consequential, all of the stakeholders, children, parents, and DCF, have an interest in having the judge only consider evidence that is accurate and reliable. Statements made to government officials are not inherently accurate and reliable merely because the government official records them. Appellate cases in this Commonwealth so hold.
Well, what do you do with adoption of George? What's the limiting principle of adoption of George? And it's hard to discern. Judge Cass, in the opinion, says that there's no reversible error regarding the documents. But there's a holding somewhere in there about the DCF reports and dictation allowing in a second level of hearsay. No limiting principle at all. What do we do with that?
George is a 30-year-old case, and I would say it is not a holding, it is dicta. And there are two problems.
George has been followed for 30 years, though.
I'm sorry?
George has been followed for 30 years in every single case decided since then. So it's not as if we have a 30-year-old case. We have a 30-year-old practice we're dealing with.
It has not always been followed.
Right.
It's been followed in some cases, in some ways, by some courts.
Really? I mean,
It
I think I've heard hundreds of those cases on the appeals court, and almost every one of them contains one of these reports, right, which uses this type of reliance. I'm not saying it's correct or not, but you're talking about a fundamental shift in the way we handle these cases, correct?
No. George only talks about mandated reporters and the duty that they may have to report. In this case, look at footnote 2 in the appeals court decision, which tracks exactly what the trial court judge said he was going to do. He said he was going to take in all of the statements subject to rebuttal. So that already deviates from George, which seems to say it only applies to mandated reporters. By saying that the trial judge here saying he would take anything in, that meant what a neighbor said, what a friend said, what a former partner of my client said, that all of that could come in subject to.
So you're saying when the appeals court, again, hundreds of these cases have been reviewing them, that they have drawn this distinction, or the trial judges have drawn this distinction between separating out report statements by mandated reporters, which include a number of different types of government officials, right? And the other type of statements. They've done that consciously in the case law?
I'm saying in the trial judges, what happens at the ground level has been an inconsistent and inaccurate application of George, if there even is a holding in George that the courts.
Well, a holding in George, that was my first question. And I don't know about inconsistent for sure, but we're moving way too fast. We've got to take a step back.
Certainly.
The DCF reports, forget the second level of hearsay for a moment. Do you agree that the DCF report is a official report and it falls within a hearsay exception for official reports for primary facts?
In this case, the reports that are in question, the dictation and the court reports by the deceased social worker and the 51Bs I am not disputing that those are official records which are admissible for primary fact.
Can you define a primary fact?
Primary fact would be facts observed or seen by the author, not things that he heard from other people that he records.
Well, what do you do with the statement in George in response to that answer to Justice Cypher's question? More leeway relative to admissibility may be given on matters of opinion if the source of the opinion is available for cross-examination.
I'm not arguing about opinion. Opinion should be excised.
Well, wait a
And
minute,
the trial
that's not-
judge here excised.
Oh, wait a minute. I just read to you from adoption of George about when there's opinion, more leeway to admissibility of opinion should be given if the out-of-court declarant is actually available for cross-examination.
In this case, the declarant was not available. He was deceased, and the issue of opinions did not, that's not the issue here, because the trial judge at the outset said that he was going to strike, he was going to excise all opinions from the record.
So were they excised from the record?
There are some, and I cite specifically in my brief to some instances which it did not occur, but that's not the issue. The issue is the hearsay, the statements from other people who were under no duty to accurately and reliably report to the DCF official. It's those statements.
And those were objected to by mother?
They were. Each one of them, she wrote a very meticulous motions in limine. They're in the record appendix, in which she specifically objected to daycare workers who just made random calls to talk about one of the children. Mother's therapist who wrote a letter, and the letter's not even part of the record, but the DCF social worker talks about the fact that there's a letter that he received from the therapist, and that summary he made is a statement in his running log, in his dictation, that the judge then relies on in terms of talking about mother's mental health. It's those kind of statements, just because the DCF worker received them and recorded them, that those are the statements that the court should not have relied upon.
But you don't want,
Fine, where's the line? So if a mandated reporter, in the process of making a mandated report, makes a statement to the DCF worker who records it with his dictation notes, is that second level of hearsay admissible under whatever common law exception George established?
Well, if it's a mandated reporter who is calling in to report suspected abuse or neglect of a child, there's a very low bar for that kind of report. We want to cast a wide net there in case there are children who are at risk. So accuracy isn't the goal.
So George
at
at
that
least
section.
establishes that. In response to Justice Kafker saying,
no, but
we've been
you're
living
saying
this.
the opposite, aren't you? You don't want that in either. All you want to allow in, you want every single person to attest. Maybe I'm misreading your brief, but my understanding is you don't want to allow in mandated reporters unless they observe something themselves, right? You want only, I'm not sure what your rule is in response to Justice Lowy's question, because I think you're trying to wipe out everything except for observed facts.
I want accurate and reliable information before
Well, but
the
that's
court.
not
And
helpful.
George,
What is your rule?
I want those people who see and have firsthand knowledge about the child to be witnesses before the court.
So if say a child, a friend of a child says that the child was abused, tells that to a teacher at school, what's your rule? Can that statement be included or not?
When it's in the DCF record, it cannot come in that way.
Oh,
But
so
in
that,
these
but so the
cases-
reporter's statement that she was told by the child's friend that she'd been abused. None of that can get in.
Well, mandated, reports made by mandated reporters, the 51As, there already is a rule about that. Those reports,
51.
But that's not for the truth. Let's take just, see if you can answer this question. I know it's a difficult question, but put the friend aside for a minute. If a mandated reporter is making a report to DCF and the DCF worker records it in his running log, in his report, does that, we don't have a name for this, whatever adoption of George hearsay exception is, but does the hearsay within the hearsay in the report, if made by a mandated reporter in the context of making that report, is that a hearsay exception that exists from adoption of George?
no, it does not. Because George makes an assumption that mandated reporters have a duty to accurately and reliably report to DCF. And that's not how it works, and that's certainly not how it worked in this case.
So is your concern that mandated reporters will report inaccurate information?
No. At the initial stage, when they make that report, when they're under the mandate to
Yes.
make the report, more is better. Say what you think may have happened so that it can be investigated. But that's not what's at issue here. This is a year, 2 years after
Yeah, but you're-
reports have been made, investigations have been had, and the case is progressing towards trial. There are random check-ins that the social worker does with some of these professionals. He gets an email from one of the daycare providers. He gets a letter from the therapist. It's just the case is progressing along, and he is just recording those statements.
Just step ahead again, though, okay? I mean, you say that that's not admissible because the mandated reporter is not, at that point in time, responding to the mandatory obligation. I understand that. I'm not saying I agree or disagree with it. I understand it. But when the mandated reporter is making a mandated report, I mean, to get to Justice Kafker's question about friends saying something, your position is that the mandated reporter, in making a mandated report that finds itself into the official record, doesn't even constitute second level of hearsay exception.
Right.
That's what you're saying,
That is
correct?
correct.
Okay, so during this trial, this process, it took 2.5 years.
Correct.
The mom had 2 more kids during the trial, and they weren't twins. So, there's a very famous evidence case, Dallas County versus Commerce Insurance, where the judge says that the rule against hearsay can't be a rule against common sense. How long are these trials going to take, ignoring to the detriment of families, if the mandated reporter making a mandated report has to be called in by the party with the burden of proof, not just subject to subpoena by the other side? This trial took 2.5 years. Are we ever going to finish these trials? And how are these juvenile court judges going to parse this when they have to make assiduous findings?
I acknowledge that what I'm asking for may, in some cases, cause some trials to take longer.
Well, isn't
However,
it going to apply to every case?
But let her finish, please. Go ahead.
in George, the justice talks about it being an artificial process if we don't allow in this second-level hearsay. And I would suggest that there have been a lot of cases coming from this court in the intervening 30 years, adoption of Mary, adoption of Sherrie, care and protection of Zita, that recognize that due process and properly admitted evidence and opportunities to meaningfully cross-examine witnesses are critical in these kinds of cases. So although the process in some cases There may be a few additional witnesses. I would say for the issues, for what's at stake, that this is not going to be damaging to children and
Aren't you
families.
dramatically underestimating the change this would entail? What the current process is that if you want to cross-examine any underlying witness, they have to be available for cross-examination, right? Every single one of them is available. This is also a unique environment where the parents, in many ways, know the facts better than anyone else of what actually happened out there. So they can pinpoint areas where they think this is inaccurate, and they can always bring someone in for cross-examination. What you're proposing is this dramatic shift where every single underlying person will have to be brought into court. That's going to mean that the people out there in the field are going to now be brought in on every single case, correct? I'm not saying you're wrong, but you're talking about a fundamental revision of the way we do these things.
I would say I'm not, and one thing we haven't...
Tell me how that's true, given that every case builds upon multiple witnesses.
Because one thing we haven't discussed at all this morning are court investigator reports. And court investigator reports, those are neutral fact finders, investigatory arms of the court that prepare reports for the court. Those reports can and do contain multiple levels of hearsay. And those reports, that's part of the practice in these courts. And there are all of those people that come in. They are not always called as witnesses. Decisions are made about what is the critical evidence, what can the parties agree to. So this isn't going, respectfully, this isn't going to change the process.
Do you have a sense of the percentage of cases in which we rely on a court investigator versus a DCF type of investigation? I just have no idea.
I cannot quote a percentage and don't want to say that.
And you've been doing this a long time.
But I do know that those court investigator reports exist in every single case. They're mandated by statute to exist. So those reports with that chalk level full of hearsay, they have been part of the record for many years without it prolonging the cases. And so this addition, this change will not make most cases any longer. I see my time is ending, and I would just ask, and if the court can conceptualize it this way, that a DCF worker cannot, over a hearsay objection, testify as to what a collateral has said to her if the government is seeking to admit that statement for truth. But according to Luke, lodging that same objection to information from the same collateral, if it's in the record, even if it's embedded in the record in a report in the record, isn't sufficient to keep the out-of-court statement from coming in for truth. Such a holding, it's wrong. As to my client, the remedy must be remand because the judge relied on this embedded hearsay and it is too intertwined with the admissible evidence to separate out the basis of the judge's conclusion. As to all other cases going forward, this court must issue a decision that will not allow for a hearsay dump, and that's what it is, upon which judges will rely in making these most consequential decisions affecting children and families.
Chief, may I ask a question?
Yes,
please?
of course.
Now, CPCS has filed an amicus brief. CPCS has filed an amicus brief in which it says that it urges us to hold that the DCF's official records are admissible for primary fact, limited to the actions and direct observations of the DCF employee who authored the document. And secondly, hearsay is inadmissible in DCF's official records only if it satisfies the independent hearsay exception. Do you agree with that?
Yes, I do.
You adopt that position?
Yes.
Okay.
Chief, could I ask an additional question as well, please? You make an important point in your reply brief about all this independent evidence that in the child's brief, which is, it has a terrific graph in it, about all the independent evidence, and so why this evidence that came in, you say, that was inadmissible, doesn't create an error. I have one question about that, though. You make the point that the only reason it exists is because the mother had to be called in response to the DCF worker who tragically is not there.
Correct.
But all of the mother's statements in the DCF report are admissible under the second level of hearsay of statements of a party opponent. So if you consider all of those statements as admissible, do we still, does in light most favorable, and the judge's determination of what he considered, does it require a remand when you consider the mother's second level of hearsay?
Yes. And
Why?
again, mother had already testified in this case. She was the first witness
Right.
for DCF. So again, she would not have to have been called in the defense case. The burden is on the state.
I understand.
The mother's counsel did not have to call mother, but she only had to call her because all of that hearsay, inadmissible hearsay, had come in, and she needed to respond to it. So I just think that the process, it got so tainted that I think in this case that the only thing we could do is remand.
I have one more question. If Mr. McMurrow had not died and had testified to, or sought to testify to hearsay that he had been told by school teachers or daycare workers, would that be admissible?
No, it would not. And that's a perfectly valid and appropriate and consistent objection. It would have been lodged. That's hearsay. And the judge, of course, would not have allowed it to come in. So allowing it to come in through another way, it just doesn't make sense.
Well, you say it doesn't make sense, but and it doesn't make sense in any other context. But you mentioned the investigator reports. And when there's second levels of hearsay in the investigator's report, and if the investigator were on the stand, he or she couldn't have testified to that. So that's counterintuitive too, but somehow in the investigator reports, the second level of hearsay is anointed with fragrant oil and comes in. How do you reconcile that?
The court investigator is not a party in this case. He's not an adversary of the parent.
No, I understand that. But in response to the chief's question, assuming you're right, and I'm going to assume you are on that, when the court investigator report comes in, that same second level of hearsay that couldn't have come in on the witness stand can come in, which means that when it comes to evidence, these hearings have some different rules than we used to.
They do, and there is that narrow rule for the court investigator, for those neutral parties. And we get it. This is about kids. We want to make the right decisions. The judges want to have a lot of information. So even though it's a hybrid, it makes sense. But but we extend, and the legislature and our court decisions have only extended that to those neutral investigators, not to the statements that DCF workers record in their official records. We're treating DCF like we're treating every other party in litigation. We've crafted this exception for the neutral, unbiased, specially trained investigators.
With the chief's permission, could I ask you to submit a 16L letter on exactly what you think the hearsay, common law hearsay exception in adoption of George means as it relates to DCF reports?
Of course.
Certainly. Thank you.
And all sides are invited to answer the same question. Ms. 16L. Thank you. Mr. Preiser.
May it please the court, Brian Pariser for the Department of Children and Families. Just a few weeks ago, this court handed down a new decision regarding the admissibility of hearsay. It's not a child welfare case, and it's not strictly on point here. but it is instructive. This court's noted that we have common law hearsay in this jurisdiction. We don't have a code, and we allow it to be flexible, and we allow it to develop over time to meet the needs of proceedings. And this court said that all exceptions to the rule against hearsay are grounded in a circumstantial probability of trustworthiness and a necessity for the evidence. That's Hedberg versus Wakamatsu, just handed down in July 11th of this year. That's really what we're dealing with here. We are dealing with hearsay. We are dealing with a need for a wide access to all relevant information so that trial court judges can ultimately rule in the best interests of children that are before them. This court has noted exceptions to the rigid rules against hearsay being admissible in many other proceedings, not just child welfare proceedings. This court has noted that hearsay can be determinative in revocation of probation proceedings. It can be admissible, determinative in Section 35 commitment proceedings of the mentally ill. There are even cases that allow for the commitment of sexually dangerous persons based on
Counsel,
hearsay.
do you see a difference in cases where there's a jury versus a judge and how we handle this?
Yes, absolutely. And I was going to get to that point because that's a critical distinction among child welfare cases, is that these cases are tried before benches. And they're tried before experienced expert judges. And I would direct this court actually to an appeals court decision, I think from 1991, but is still perfectly applicable here, Custody of Tracy, where the appeals court noted just that and cited decisions of this court that we can expect as a matter, and I paraphrase, as a matter of both our experience and of law, that judges will not be unduly influenced by unreliable and flimsy evidence.
Can you,
But you're not suggesting that in a criminal trial, the rules of evidence differ depending on whether it's a bench trial or a jury trial?
I'm not addressing criminal trials,
Okay,
the
but I mean,
admissibility
so-
of evidence in criminal trials.
So I would be reluctant to be claiming that the rules of evidence go out the window because it's a
Well,
bench trial as opposed to a jury trial. Isn't the key difference here that in many cases we're focusing on a single event, and with regard to these matters, we're focusing on entire lifetimes of a parent and a child?
yes, and that's a critical distinction that makes these cases somewhat unique, unlike criminal cases, which also have constitutional protections.
Right, well, it's not that
But
different
aside from
it's
that-
not that different from the SDP cases, and it's not that different from the civil commitment cases where we do the same thing. We're evaluating not a single event, but you're evaluating lifetimes.
That's right.
But in those other matters, SDP specifically, the legislature has spoken of what's admissible and basically given a wide leeway. The legislature here has spoken in some of these cases as well, I gather, with regard to the court investigators under 119, Section 24. Is that by statute that
Well,
everything
yes,
comes
that
in?
it's actually Section 21A, which
21?
defines the admissibility of evidence in care and protection proceedings, which interestingly not only acknowledges the report of the court-appointed investigator, but also the reports of DCF personnel who performed an investigation of these matters. That's listed in the statute as well as admissible evidence, the same statutory provision that provides for court investigations. Obviously, there is a plethora of case law from this court and from the appeals court about the admissibility of hearsay contained in the court investigation. That's not contested. It's interesting to note that DCF records that are admissible pursuant to the same statute also should be admissible to the same extent. It's the same statute that creates the admissibility. And then that, I want to be clear, we're talking about Section 21, what are commonly referred to as Section 21 reports. The department writes a court letter, writes a report. That is somewhat different, perhaps, than some of the documents that are at issue in this case. In this case, we were talking about social workers' dictation. We were talking about maybe service plans and assessments. These are documents that fall under a common law exception that George recognized, the official records exception. So I would submit that when we talk about DCF records in the aggregate, there are actually several different provisions for admissibility that may apply differently to different records.
Okay, and that's why I guess maybe your familiarity with these is far exceeds ours. So if there had been a report here, if the person had lived and decided to write a report under Section 21, then that, as a matter of statute, the hearsay would have come in.
I would submit, I believe the record does include reports written by social workers here. And I would argue that those are not subject to the common law official records exception. Those are subject to Section 21A, the statute that provides them. And I'd just bring to this court's attention care and protection of Bruce. That's an appeals court decision that some time ago made that distinction.
So we have some statutes which have spoken to the issue and have given some degree of leeway with regard to it. And
Yes.
the question here is whether where the statute does not apply, whether we should apply the common law to give comparable scope.
Yes, and Your Honor, with respect to that, again, I would bring the court back to custody of Tracy that I cited. In there, the appeals court noted that the need for court investigation reports, including hearsay, was necessary to allow the trial court to navigate the cross currents of these cases, to have access, if I may, I will quote from it, to steer a wider course as possible. The need for accurate information is best served if the parties here have the opportunity to rebut the report, including the right to cross-examine the investigator. The judge can consider all the evidence and give each piece the appropriate amount of weight. And what I would submit is, as Judge Kafker recognized, over the past 30 years, the appeals court has considered the admissibility of DCF records, the official records now, and has considered them in the same breath with court investigators' report. This court has, and I cite in the brief to the Brantley decision, where this court, relying on appeals court decisions, talks about hearsay being admissible in documents in care and protection proceedings where there's some indicia of reliability.
But what's Brantley really mean? It's dealing with a protocol in Hampden County in the probate and family court that's sui generis and it's not dealing with this issue, and it's misciting cases that it's relying on for the principle that you just articulated. So how much can you do with that?
I don't know that it miscites
And I
them
went back and read
respectfully.
each one of them, but okay.
But what I would submit is that I agree with you. It's not a decision on point. What it is instructive because of the distinction that it draws. In Brantley, that hearsay was deemed beyond the pale. It was deemed inadmissible. It was deemed unreliable. And it's contrasted expressly with the hearsay that's included in the reports that are admissible in care and protection proceedings.
Your sister says that you don't really need this because you could rely on court investigators to do this. Could you respond to that? Because there's some attraction to that.
I can appreciate that, but it overlooks really the fundamental structure of a care and protection matter. So if one goes back and looks at the procedural rules that are in place, hypothetically, if a care and protection is filed in January of a given year, a court investigator is appointed at the outset. That court investigator will likely file a report, say, by March or April. Okay? Many of the times, that will obviously include what brought the matter to the court's attention. It will include some background history regarding the family. Ironically, I would say, parenthetically, it's interesting to note that my sister would have you excise hearsay from department records where it exists, but if a court investigator speaks to the department worker, identifies the worker and identifies the hearsay, this court has drawn no distinction between levels of hearsay. So the very hearsay that my sister is arguing is inadmissible in the department report is magically admissible in a court investigation if everyone's identified.
So she's saying, she's saying that they're impartial. You're a mixture of prosecutor and caretaker of the child. You're not as trustworthy. So I understand, she says the court investigator I'm not going to object to, but I'm going to object to your stuff.
I understand that. I am only citing the fact that to the extent that that report is relied on by the court investigator, it becomes admissible. I also respond to that in my brief, the department's statutory role with regard to families and the creation of many of these records prior to becoming some sort of an adversary. But that brings us
But I'm
back-
just trying to get to the practical, and I don't mean to cut you off, but I'm confused. I thought this would be incredibly disruptive, but if there's a court investigator in every case, is there a court investigator in every case?
There is, and that's by statute. But thank you for bringing me back to your initial question, which I sidetracked myself on a parenthetical. I apologize to the court. Nonetheless, as I said, if a case is filed in January, a court investigator by statute is appointed automatically. That's at the beginning of the case. That report is filed perhaps, if it was an appointment and it was made in January, it's in March or April. We know that these cases do not come to trial at the best within 12 months or 15 months or 18 months, even if the guidelines and the rules are all adhered to. It is over a year before these cases come to trial. Sometimes they come to trial for an adjudication, and perhaps not, I apologize, perhaps not for a termination of parental rights until well after that point. It could be 18 months or 2 years. At that point, the court investigator's report is part of the record and it's admissible, but it only speaks to what happened 6 months, a year, 18 months ago. The court investigator is no longer involved in the case. Even at 12 months, the court investigator's information is going on a year old. It is the department social worker who is involved on a daily, ongoing basis with the family, is fulfilling the role of the social worker of speaking to the collaterals and bringing the information to the court. Information that, by the way, under juvenile court rule is required to be brought to the court's attention because the juvenile court rules require the department to file those Section 21A letters.
Can you also address the chief's question? Because about, okay, if this person had lived, he wouldn't have been able to testify to this hearsay, but his report is admissible. How do we reconcile that?
I have no better answer than Justice Lowy observed, in that the same rule applies to a court investigator. I would imagine there might be some leeway if the hearsay was uncontested and the other person was a witness or the parent, that some of that might be permitted in testimony. But as a general rule, the worker cannot speak to hearsay, but we're talking about a documentary exception to the hearsay rule. That does apply to court investigators as well. So there's really, at its heart, the department is asking this court to recognize, as I believe the brief lays out, that courts have recognized for now several decades, that essentially these documents serve the same function as court investigator reports. The appeals court recognized, again in Tracy, that it stands to reason an investigator will, in recognizing hearsay, will talk to collaterals and third parties and teachers and neighbors.
Well, can I ask you about, our first job here is to do no harm.
Yeah.
And we don't have a way to gauge, what's going on with termination of parental rights, C&Ps, at the trial level. And you've differentiated between the official reports under 21A and sort of what I assume you would say is an official record, which is the DCF record that we have here to some extent. So is there a consistent way that this is being addressed by juvenile court judges? And what I mean by this is adoption of George, whatever that common law hearsay exception that was created, followed consistently at ground zero. What's going on relative to this issue in the courts?
We have, it's hard for me to speak other than anecdotally what has been done across the Commonwealth, but this much I can say. It is common practice now for the department to submit its documents as official records. Those include hearsay. It is accepted practice, as was done in this case, for the parties to file motions in limine when they have objections to portions. Many of those motions in limine will include objections to hearsay, as was done in this case. I would suspect that there may be some variety among individual judges as to how they rule on those. That would just be my guess. But at the end of the day, what I would say is that this is a rule of reason. And
but
here, yes.
Can I, on one point on factually, your sister says that you basically dump huge amounts of paper right before trial or right before the 72-hour hearing. I mean, George is sort of based on the assumption that the parent knows the facts here, and if they know someone is lying about them, they can bring that person in and cross-examine them. And your sister says that's not real that doesn't work in the real world because you guys are giving them the paper so late in the game that they can't really cross-examine people. Could you respond to that?
Firstly, the ongoing dictation and the case record is produced long before a trial that's held 12 or 18 months. There are juvenile court rules on the timelines within which the department must produce its case record. It is well before, as a matter of fact, it is before other hearings required by rules such as motion status conferences and pretrial conferences to address those issues, to allow for those motions in limine. So it is not done on the eve of trial. Secondly, I would submit that this case is instructive. The department did not offer up its 90 pages of social worker dictation at the beginning of this trial. It did not offer up those pages of dictation until it was forced to do so because of the untimely death of the social worker. It was a poor substitute for the social worker's testimony. The department called the social worker in this case. The social worker testified in this case. Unfortunately, he died before he was able to be cross-examined, and the judge, rightfully so, struck his direct examination because there was no opportunity to cross. This documentation with identified sources was brought in as a substitute because there is no adequate substitute for what the social worker saw when there was no court investigator doing his or her job. It was something that was necessary. It was necessary to allow the trial judge to rule in the best interests of the children. It is not a regular practice, I would submit. And as support for that, I would merely say that whatever adoption of Luke stands for, it does not in any way stands for a change in the burden of proof. The department is well aware that the Commonwealth always bears the burden of proving a parent unfit by clear and convincing evidence.
Do you think the appeals court decision as it relates to second level hearsay was too broad?
No, I think it falls firmly within the pattern of case law that has developed over time.
And if you mentioned identified sources, what if it's an official report? It's the 21A report. What if in the 21A report it says, I spoke to a daycare worker who told me, and we don't have the name of that daycare worker? What happens there?
I think that I would argue on that particular point, it might depend on the context of the record. If it's clear who the worker is from other documents or other matters in the record, I think that's sufficient identification. If it is, I spoke to a person, I don't know who it was, that would be an unidentified source perhaps. But that would depend on the other complementary evidence that might be submitted at the time. But that rule comes from the court investigator's rule. It would apply, I would argue, to Section 21 reports, and I think it would apply to these official records, because it is that identified source and the ability to rebut and cross-examination that source that lends it its credibility. It can be tested, ultimately.
Now, in Zeta, which is our most recent statement, I think, we're speaking about 21A reports, and it says that subject to certain limitations, reports prepared by the department's investigation of the facts relating to the welfare of the child may be admitted in evidence at the discretion of the judge, citing Chapter 119, Section 21A, and then it goes on to say the limitations are clear. First, the reports must be limited to a statement of facts or redacted to exclude opinion, diagnosis, or evaluation. Second, the opposing parties must be able to cross-examine the author of the report should they request so to do. Are you challenging that?
Well, are we talking about Section 21 reports, or are we talking about official records under the common law hearsay exception? They're different bases, and I would argue the rules might be different.
Are you saying that should be broader?
You see, in Zeta, as I recall...
If it's a dictation of notes, no, I mean, basically in Zeta it was not admitted. It didn't allow it in, but this is a statement, this is a declaration of what Chief Justice Marshall and the court at that time understood to be the law,
Right.
and are you saying that that is not the law as to other types of reports, that it should be broader than this, or that the limitation should not apply?
In Zeta, as I recall, we were dealing with an appeal from a 72-hour hearing. And in that case, the affidavit that was filed with the petition was not admitted. And even if it were, I believe the court said there were problems. It was unsigned. It was unsworn. That was Zeta. I would submit there was that here, right, if we are talking about the official records exception, see, the court investigator, case law regarding court investigation reports, and therefore Section 21 reports, the case law requires that the author be present for cross-examination. That's the check that's been required over case law. The official records exception is a common law exception that stands on its own. It makes the document itself admissible. The first level of hearsay is cured because it's an official record.
Isn't Zeta
So-
tracking George? It seems like Zeta is sort of tracking the reasoning of George, isn't it, in that statement, or is it not?
It may be, to be honest, I'd have to look at that
But-
particular
but
portion
now,
again, and
I
I'd be
mean,
happy to address
I'm trying to
it.
now figure out, because I mean, I agree that Rule 1 is to do no harm, but Rule 2 is to do something that's sensible.
I agree.
So we have these official reports under 21A, which are admissible, and unless this court was wrong, whatever, 8 or 9 years ago when it wrote Zeta, it set forth those limitations, no
Correct.
opinions, and the author, the DCF investigator, must be available to testify.
Yes.
Put aside the death here as to whether that creates an exception, but if the DCF investigator is alive, is it your view that what the DCF investigator wrote, whether it be a report or whether it be dictation notes, would be admissible with regard to opinions, and/or would be admissible if for whatever reason that person is not made available to testify?
So, again, the Section 21 reports follow the case law from court investigator reports, and therefore, a requirement there is that the author be available. Official records are a common law exception. What we've been arguing about here today involves multiple levels of hearsay. The first level of hearsay is the document itself. It is the official records exception, George, that allows for that first level of hearsay to be overcome. And my sister agrees with that. Nobody disputes that it's an official record come in. And as far as I know, there is no case law on official records that requires the author of the official record to be present for it to be admitted. It is admissible because it's a presumption of reliability of the record itself, not counting this multiple level hearsay, that it is reliable, and that overcomes that exception to the hearsay rule. Now, with regard to the second level hearsay contained therein, it's the department's position that case law has considered these with court investigators and says that information has to follow that rule so there's reliability. Either, as George says, it was reported by someone who has a professional obligation to keep accurate records of that information, or there's an ability to test it. Okay, that person needs to be available. However, I would say Mr. McMorrow's death, and of course that's not necessarily relevant here because there's also the independent statute that provides for the admissibility in the event of his death. But Mr. McMorrow's unavailability, were it for other reasons, would not make his documents inadmissible on their face. Now, that's a general rule, and I recognize that we need to do something sensible, and I recognize...
I hope that the death of the investigator is a very, very unusual circumstance, but it's not an unusual circumstance that you're seeking to author reports, and I'm just trying to figure out whether your position is that when a DCF investigator writes a formal report
Yes.
under 21A, that the Zeta limitations apply to that report, and that those limitations somehow differ when the DCF investigator is informally taking dictation notes, and that somehow the limitations that apply to a formal report would not also generally, put aside the death, apply to the informal report, which is dictation notes.
I apologize, Your Honor. I will need to go back and look at Zeta more closely with regard to that issue. What I will say is I am comfortable saying that the formal report stands in the same shoes as the court investigator's report.
But it
So
is
it is-
counterintuitive.
I'm sorry?
Again, that the Chief's point, it's counterintuitive that the official record is going to allow second-level hearsay to such a great extent compared to the 21A
Well-
statutory report. That is a little,
I appreciate that, and I would say to the extent that it's inconsistent and unacceptably inconsistent, to that extent, I would say the common law rule trumps because, and not because it trumps a statute, it is only because most everything that's in the Section 21 report comes out of the department's record anyway. So the material you're looking at is all coming from the same source. So it does not make sense that it would necessarily be admissible if the source is.
But I guess the bottom line is, there apparently is no question that if the department seeks to offer a 21A report, based on what Zeta has said, what this court has said in Zeta, that the investigator must be made available if the parent wants the investigator to be called, correct?
I will agree with that with this argument, though I have not read Zeta in
Okay.
some time.
Well, I just read it to you, so.
Then I accept it,
The
yes.
opposing parties must be able to cross-examine the author of the report should they request so to do.
Yes.
So, that's Zeta, trust me on
Yes.
that. And it's a quote from a care and protection of Bruce, so I'm just trying to figure out what your position is. Are you saying that that limitation does not apply if we're talking about dictation notes?
I would say that if we're talking about dictation notes, and mind you, I guess this would be a distinction to the extent it's counterintuitive. A court report is written in contemplation of litigation. It's produced for the court. There is that factor. Dictation notes are not. Assessments are not. 51Bs are not. None of the other general documents that the department clinical staff produces in the course of performing its official duties are produced in contemplation of litigation. A court report is produced for the court. So that might be a distinction if the court is looking for
But I
one.
guess the bottom line is, if a parent says, Your Honor, I don't think that the social worker's dictation note should come in unless I'm able to call the social worker, are you saying that's wrong?
Well, I would think that the observations directly made by the social worker may not be able to be cross-examined. That's different from the hearsay included therein. If you have an issue with the individual the social worker spoke to, you are going to find it more fruitful to go right to the source and to cross-examine the person who made the statement.
Try my question. It's not, the question basically is, does the parent have can the parent say, or are you saying that if the DCF says, no, Your Honor, we don't intend to produce the DCF, the author of this report, whether the dictation note should then come in?
Well, it's not a matter of don't intend to produce. I don't think the department can withhold a witness. If we are unable to produce the social worker for some reason, I think the first level of hearsay is satisfied by the common law exception, which does not require the presence of the author.
And that would apply to the dictation notes, but arguably not to the report, based on at least what Zeta has said.
Arguably not.
But isn't the spirit of George to require, if you rely, I mean, we're not concerned about opinions. We're really concerned about these fact statements that end up in these 140 fact, findings in each one of these cases. Doesn't George still require you to produce for cross-examination the person who made the factual statement?
Right.
That's the underlying protection, isn't it?
Yes, and that's
And that, I mean, the chief's question, I'm just not sure why you don't agree with the chief on this, because cross-examination for facts, that person has to be available, right? Unless they're dead or something, but don't they have to be available if, for example, the person who wrote the report spoke to another DSS employee, and that employee said, I saw the house was in terrible condition. Doesn't that person have to be made available for cross-examination?
yes.
So that's not that. If you've got a fact that's in dispute, George still requires the person who made that factual statement to be available for cross-examination and be subpoenaed.
I apologize if I was unclear, and I might have been by this
Maybe I didn't
point,
understand the chief's question, but that seems to be what
I was
thought.
merely talking about the first level as opposed to the second level. I would agree, and that's what I was saying, that essentially, the direct observations made by the author of the report, that person would probably have to be cross-examined if the social worker himself went to the home and observed it. That is perhaps somewhat different than speaking to another social worker who is available for cross-examination.
So you're saying the first,
No,
I'm not sure you have that right.
No, I don't, and I apologize after the time I've been here in argument that I've tripped over
I think you
myself.
got that one wrong.
But that still would fall under, there's a hearsay exception for official records. That covers the whole first level, which would include the author's direct observations. The first level hearsay is the document and the direct observations of that social worker.
So the adequate declarant does not have to be available for cross-examination in those circumstances?
Not under the common law exception to the rule
But
against
how about
hearsay.
how about with regard to the due process overlay, since a liberty interest is at
If
stake?
there is insufficient way to rebut that information. And that information, I grant you, cross-examination is a primary way that we consider to rebut. It is not the only way. And I would concede that there are situations in which a due process violation could arise. But that varies in case to case, and that's up to the individual judge to make a determination. Yes, if we have a dead social worker, and if we put in all of the social worker's observations over, years of time, and there is no ability to cross-examine that social worker, or other people who've seen the home, and that is the sole source, because the department calls no other witnesses, something like that could rise to a due process violation. That's not what we have here, by the way, in this case.
Keith, I apologize. Can I ask one more question? Sorry. The evidence guide, I want to ask you if the commentary in the evidence guide is wrong. Comment to section 1115. It says, the exclusion of expressions of opinions, evaluation, or judgments from official records is a practical working rule that has exceptions. More leeway relative to admissibility may be given to material that smacks of opinion if the source of the opinion is available for cross-examination. Is that?
That's directly taken from case law. That's care and protection of adoption of Vidal, which also cites back to George, I think. Cases have always recognized that there's more leeway involved in opinion and judgment when you have a licensed social worker who's available for cross-examination. That's not a hard and fast rule. That is something the trial judge has leeway with, yes. And that's straight from case law, that commentary.
All right, thank you.
Thank you.
Mr. Cohen, we've not forgotten you. And you're here to tell us, I'm sure, that as to the child, it doesn't matter how we rule on all this stuff, huh?
May it please the court, Justin Cohen for the child. There was more than enough clear and convincing evidence, testimony at the trial that mother was unfit and to terminate her parental rights to the child.
So do you think that if we were to make an adjustment to the rules, this would not require a remand because there'd still be sufficient evidence if we went through and looked at it all?
Yes, exactly. There's that independent basis. And because my child, this child client's case is so strong on the facts, I don't advocate for a sweeping change in the hearsay law going forward.
Now, I read your very careful delineation of each of the items which you claim potentially could come in and why you say they would not affect the outcome. Your sister responds to that and says, well, because it came in, her client testified to things she might not have testified to, and therefore that the scope of her testimony, which you argue is now showed it was already in evidence, that it wouldn't have been in evidence had this not come in. Can you respond to that?
She testified over 92 pages, and there were approximately 4 references to McMurrow in 92 pages. I referenced one in one finding inadvertently, and I also referenced another citation that was not from her direct examination. And I put together a graph in the brief to this court, and because I represent the child, it's about what happened in the trial court, and the findings of fact and the conclusions of law were overwhelmingly admissible under specific hearsay exceptions in the findings.
Now it was DCF who called the mother first, I gather, correct? She was the first witness?
I believe so, yes.
And then did the mother call herself again as part of the defense case?
Yes,
So she testified twice.
that's correct.
And have you looked to see whether or not some of the things which you say were admitted by the mother came from her first testimony or from her second testimony?
I believe that, like I said, that there's one citation in one finding of fact that I inadvertently referenced her direct examination the second time about McMurrow one time, and I also said I did something else that had nothing to do with her direct later. So it's not really an issue. And the findings of fact in the trial court are overwhelmingly admissible under specific hearsay exceptions, and there were 175 findings of fact and at least 34 conclusions of law that were admissible under specific hearsay exceptions. So that supported the trial judge's ultimate conclusion that mother was unfit and to terminate her parental rights to this child. This child is actually number 7, where mother doesn't even have custody of the previous 6. And where all this, where it's so attenuated, the amount of hearsay that we're talking about here, there was no violation of mother's due process rights.
I guess pragmatically, is the child right now pre-adoption?
Yes, has been pre-adoption, I think, since he was approximately 1 month old.
By the present foster parents?
Yes.
And so the actual adoption has been delayed by the fact of this appeal, I gather. Is that correct?
Yes, that's correct.
Thank you.
Thank you.